So what are the real risks when crypto gets exposed? Well, a judgment creditor can seek a charging order against your crypto accounts. Business disputes, malpractice claims, and personal liability lawsuits can all reach your unprotected crypto. Exchange-held crypto, such as Coinbase, is even more accessible. These platforms operate under U.S. jurisdiction. There are legal strategies that actually protect cryptocurrency.
This is the Asset Protection Show. Expert strategies by attorney John Skabelund.
Welcome to the Asset Protection Show. I'm your host, attorney John Skabelund. Imagine you've built up $500,000 in cryptocurrency over the past few years. You feel protected. No one can find it after all. Well, if you're hit with a lawsuit and a court orders you to disclose all your assets, your crypto is on the table. Today, we will discuss why crypto is not automatically protected and what you need to do to actually keep it safe. The law says that cryptocurrency is personal property. The IRS formally treats cryptocurrency as personal property. This means courts and creditor proceedings feel the exact same way. What this means to you is that it's subject to a judgment lien, court-ordered disclosure, and for sale, just like a house or a brokerage account. In other words, a court order can compel you to disclose all your holdings, including cold storage wallets and hardware wallets. Now, there's a myth that because crypto is anonymous, that it's somehow protected. Blockchain transactions are synonymous, not anonymous. All transactions are permanently recorded. Blockchain forensic firms used by creditor and law enforcement can trace wallet activity. Simply refusing to disclose crypto holdings is fraud, not asset protection, and the legal consequences are severe. In fact, in many states, it's a felony to intentionally hinder or delay a creditor. So what are the real risks when crypto gets exposed? Well, a judgment creditor can seek a charging order against your crypto accounts. Business disputes, malpractice claims, and personal liability lawsuits can all reach your unprotected crypto. Exchange-held crypto, such as Coinbase, is even more accessible. These platforms operate under U.S. jurisdiction. There are legal strategies that actually protect cryptocurrency. One of my favorites is the LLC Wrapper. By placing cryptocurrency in a properly structured LLC, it creates a separation between your personal liability, meaning your car accidents or lawsuits against you personally, and your digital assets. When you no longer own it in your name and it's in an investment company that we create in the form of an LLC, you do not own it. And because you don't own it personally, it's out of reach from your personal creditors. A charging order against the LLC does not give the creditor ownership or control of your cryptocurrency. A charging order only entitles the creditor to any distributions if and when that LLC makes them, and it becomes a waiting game. This charging order protection makes the LLC a far less attractive target for litigation. Further, it's important that every LLC has poison pills in the operating agreement designed to thwart plaintiffs from seeking to attack the membership interests in the LLC. And that's a powerful tool. Unlike corporations that has stock, and stock, whether it's privately held or publicly traded, is all very reachable to a creditor. Membership interest in LLCs is typically not reachable. But if a judge does grant the transfer or assignment of your membership interest, you want poison pills inside your operating agreement to thwart the plaintiff. My favorite jurisdictions for LLCs to hold crypto are in Wyoming and potentially Nevis. Another common tool that we use is a domestic asset protection trust, often known as a DAPT. A DAPT can hold your crypto inside that trust, and it has spendthrift provisions preventing creditors from forcing the distributions. The issue, however, is you want your DAPT to be a holding company, not directly owning the crypto. So even if you have a DAPT, you still want an LLC owned by the DAPT to actually hold your crypto. I'd also remind you that DAPT strength varies significantly by state. Not all states offer robust protection. Every DAPT state has some limitations that LLCs simply do not. But DAPTs also aren't subject to charging orders. So it can be a mixed bag, and that's why it's important that you consult with an asset protection attorney to see what's best for you. Just like LLCs, the DAPT must be established before any legal threats arise. Reactive transfers can be unwound as fraudulent conveyances. And again, it could be a felony in many states. A beneficiary defective inheritance trust is the strongest domestic shield that we can provide. It's an irrevocable trust that legally owns the crypto, again, typically within an LLC, but it removes it from your personal estate entirely. So this also has some estate tax benefits associated with it as well. Now, a discretionary trustee controls the distributions, meaning that creditors generally cannot force a distribution the trustee chooses not to make. And there's spendthrift clauses that add an additional legal barrier. The gold standard for high value cryptocurrency protection is actually an offshore or foreign asset protection trust. These trusts are actually governed by foreign law and managed by non-US trustees. And that non-management by US trustees, meaning you, can be a problem. So again, we like to couple this with maybe a Nevis LLC that would own your cryptocurrency so that you as the manager of the Nevis LLC have direct investment control, but ultimately distributions would be subject to a non-US trustee. Common jurisdictions that I like are the Cook Islands and Belize. Now, the reason why foreign asset protection trusts are very effective in the gold standard is that creditors face extraordinary legal burdens in foreign courts. It's a significant deterrent. However, foreign asset protection trusts do have significant reporting requirements. First, let's talk about Form 3520. It's an annual return to report transactions with foreign trusts. There's also the FBAR, which means the foreign bank account reporting for all accounts exceeding $10,000. There's also Form 8938, which is a statement of specified foreign financial assets, known as FACTA. It must be filed by all U.S. persons holding foreign assets. It's critical that you file all these forms to make your foreign asset protection trust legitimate and legal. It's also important that you're working with an experienced asset protection attorney to make sure that the foreign asset protection trust is not only properly created, but it's also properly maintained. In summary, what you need to know is timing is everything. And that is the case with all asset protection. In order for asset protection to effectively protect your assets, it must be proactive. Transfers made after a lawsuit is filed or even an accident occurring can be reversed as a fraudulent conveyance. The structure must also match the asset. Cryptocurrency inside a revocable living trust, for example, has zero creditor protection. Why? Because you are the beneficiary and you directly control the trust. It is also amendable. Courts will not uphold your living trust. Don't confuse privacy tools with legal protection. Hiding assets is fraud. Structuring them is legal. So let me answer some typical questions that I get from clients. So question number one is, can a judgment creditor actually find my Bitcoin? The answer is yes, but what's important is about the timing. The great thing about Bitcoin and all cryptocurrency is it's very similar to your brokerage account or your bank account. It is completely private to the attorney that is threatening to sue you at the initial stages. So although we can find your businesses and your real estate, we can't find your cryptocurrencies, brokerage accounts, or bank accounts. What happens though is if you are sued and the plaintiff receives what's called a judgment, that is a court order that the judge has ruled that you owe the other party money, they can force you to do what's called a debtor exam. This means that under oath, you must disclose everything you own. And yes, that means your cryptocurrency. Question number two, what is the difference between holding cryptocurrency personally versus inside an LLC or inside a trust from a creditor standpoint? Well, one of the tenets of asset protection is you want to own nothing but control everything. So here's the distinction. If John Skabelund owns the cryptocurrency, then it is my personal asset, and if I'm sued, it can be taken away from me. However, if the LLC owns the cryptocurrency, you cannot pierce the corporate veil, reaching into the LLC and take the cryptocurrency from the LLC that I own. Similarly, if I am the beneficiary of a trust, such as a domestic asset protection trust or the DAPT that we talked about earlier, again, the judge cannot order that there be a distribution of the cryptocurrency to me, nor can the judge order that the trustee send the plaintiff the cryptocurrency. So that's why we love LLCs and trusts from this standpoint. Question number 3. If I set up an LLC or a trust for my cryptocurrency today, am I protected from lawsuits that may happen tomorrow? Well, the answer is not if you haven't transferred the cryptocurrency into the LLC or the trust. Again, the timing of the transfer must precede any event that would cause a lawsuit. The fact that you're threatened or that you're sued is not the key date. The date is whenever the event causing the lawsuit occurs. The key must be that the LLC or trust must own the cryptocurrency prior to any event occurring. Question number 4. What about crypto held on exchanges like Coinbase? Is that more vulnerable than self-custody? Well, the answer is yes, it is to a degree. Is it enough that would keep me awake at night? No. But if we're legally speaking, Coinbase is subject to subpoenas and court orders because it's within the United States jurisdiction. So self-custody is more helpful in the fact that we don't have a third party that the court can order disclosure through subpoenas or order or compel through a court order the distribution of your cryptocurrency. Question number 5, is offshore crypto protection legal? The answer is absolutely yes. The key, though, is that you must properly maintain the Foreign Asset Protection Trust. That means the IRS reporting requirements must be followed. If you do not follow the IRS reporting requirements, your Foreign Asset Protection Trust is subject to attack and very vulnerable. Last question, question number 6 is, what are the biggest mistakes crypto holders make when they think they're protected but aren't? Well, mistake number 1 is simply owning the cryptocurrency in your own name or in your living trust. Mistake number 2 would be to create that LLC, but not do it properly. Again, you want to have poison pills inside your operating agreement. And again, the perfect jurisdictions are Wyoming LLCs or Nevis. And then how do you determine whether Nevis or Wyoming LLC? We only utilize Nevis LLCs whenever we're doing a foreign asset protection trust. The other mistake is that you actually don't transfer the crypto account or the wallet inside your LLC. You may wonder, how do you actually transfer the wallet? Well, when it comes to personal property, a bill of sale is required where you're actually transferring it as a capital contribution into the LLC. So those are the biggest mistakes people make when it comes to crypto. And with that, we're going to wrap up today's episode. If you hold any significant amount of cryptocurrency, whether it's Bitcoin, Ethereum, or anything else, you need to have a legal structure around it before the need arises. Once a lawsuit is filed, once the accident has occurred, it's too late to protect those assets without risking a fraudulent conveyance claim. In many states, it is a felony to intentionally hinder or delay a known creditor. So it's important to talk about what structure makes sense for your situation with an experienced attorney who only specializes in asset protection, not dabbles in it. Until next time, stay protected.
You've been listening to the Asset Protection Show, expert strategies by attorney John Skabelund. For more information, go to assetprotectionshow.com.
This content is legal information only and not legal advice. Viewing this content does not create an attorney-client relationship. Mr. Skabelund is admitted to practice law in Arizona, and he may be reached at ultimateassetprotection.com.